Is that, you want to censor their
I want to
testimony?
strike it. I want to strike it. I want to strike it. If we aren't able to probe the veracity of their statements, the truthfulness of their statements.
You will be given your 5 minutes here with, when we get to the 5 minutes.
They're
of
not
questions.
here.
They're not here to
They're
question.
absent.
Understand
They
that.
cannot
You will
answer.
be able to
They
ask-
have scurried
you can-
away
you
with
can-
your complicity.
You,
they refuse
have
to
not
defend.
scurried away. They
in
were
a country
dismissed
of
like all witnesses were
330
dismissed.
million
The chair
people,
recognizes
you
Mr.
couldn't
Sauer
find 2 people
for his
to
5
defend
minutes
their
of
statements.
testimony.
That's pretty disgraceful.
Mr. Sauer,
If
you were
allowing them to
recognized.
leave is not weaponization, I don't know what is,
Oh,
Mr. Chairman.
Yeah, right.
Thank you all
It'll
for
be in order,
illustrating
Mr.
our
Sauer, you
point. Thank you.
recognize. Gentlemen may proceed.
Mr. Chairman, Ranking Member Plaskett.
Mr. Chairman, I move to adjourn. I move to adjourn.
The gentleman's not
This is a
recognized.
mockery. This is a mockery and a disgrace. And it's shameful
Gentleman's not
that you
been
participate in
recognized.
this.
The gentleman, Mr. Sauer, is recognized for his 5 minutes of testimony.
There's a motion on the floor to adjourn.
Motion to
And it is
adjourn
not debatable,
is not
Mr.
debatable.
If you don't know the rules of the committee, then talk to your parliamentarian.
Well, you weren't recognized for your motion.
Nor are you
Mr.
following the rules of the
Sauer is
committee. You can't
recognized
speak
for
out of
his
order.
5 minutes.
What are you doing? What are you doing? You're out of order.
Mr. Sauer, you
Listen
can
to your own
proceed.
words.
Mr. Chairman, Ranking Member Plaskett, members of the subcommittee. Imagine a world where White House officials email the New York Times editorial board when the paper runs a story criticizing the president. They abuse the paper in profane language and demand that it immediately pull the offending story from its website, while the White House publicly threatens devastating legal consequences if the paper doesn't comply, and it does. Imagine a world where the FBI every month sends all the major booksellers in the United States an encrypted list of the books that the FBI wants them to pull from their shelves that month and burn, and the booksellers comply by burning at least half of those books. Imagine a world where a federal national security agency teams up with a major research university to establish a mass surveillance program of ordinary Americans' political thoughts and opinions. They use swarms of analysts and cutting-edge technology to monitor hundreds of millions of domestic political communications in real time and covertly censor millions of them. These 3 scenarios do not come from a hypothetical dystopian future. The first 2 are very similar to what federal officials are doing with social media platforms now. And the third scenario is not hypothetical at all. That mass surveillance and mass censorship program started operating in 2020. Last July, the plaintiffs in Louisiana and Missouri against Biden received a limited discovery of communications about censorship between federal officials and social media platforms. What we obtained was astonishing, staggering, and horrifying. A veritable army of federal officials pressures, threatens, coerces, colludes with, demands, and deceives social media platforms to censor online speech. Our evidence shows White House officials badgering social media platforms in private to censor speech that contradicts the White House's preferred narratives, while the president publicly accuses them of, quote, killing people by not censoring enough of ordinary American speech. And the president's spokespeople raise the specter of crippling legal consequences if they don't comply. One major platform responds to White House demands by assuring them, we hear your call to do more, and it scrambles to carry out, quote, what the White House expects from us on misinformation going forward. Our evidence shows federal officials routinely flagging social media posts by ordinary Americans for censorship. It shows federal officials orchestrating elaborate plots of deception to dupe platforms into censoring disfavored speech. It shows federal officials engaging in seemingly endless meetings with the content moderation officers of major platforms to discuss disinformation and censorship. It shows federal officials serving as privileged fact checkers with effective authority to dictate what Americans can and cannot say on matters of immense public importance on social media. And it shows federal officials relentlessly pressuring social media platforms by threatening them with ruinous legal consequences if they do not cave to the federal demands for censorship. Truth is not the goal of this federal censorship enterprise. The censors have been proven wrong again and again, including on politically seismic issues. But each time the censors are proven wrong, the censorship has continued unabated, and it expands. And that is because now, as at every other time in human history, the goal of censorship is not to promote truth. It's to obtain, preserve, and expand political power. Censorship is not necessary to protect Americans' lives, security, or democracy. Systematically violating the most basic civil right of millions of Americans does not make Americans safer or healthier. Federal censorship is not democratic. It stifles the voices of ordinary Americans and places the channels of public debate under the command and control of elites. Censorship inflicts lasting harm on Americans by impeding the pursuit of truth in a free marketplace of ideas. The Supreme Court describes social media as the modern public square. For years, federal officials have been perpetrating a hostile takeover of that modern public square, and this hostile takeover has largely succeeded. Congress should take swift action to banish the federal censors and restore the freedom of speech to social media. I welcome the subcommittee's questions.
Thank you, Mr. Sauer. Mr. Seligman, you're recognized for 5 minutes.
Mr. Chairman, Ranking Member Plaskett, and members of the committee. The focus of today's hearing is allegations of censorship by social media platforms, purportedly at the direction of the federal government. Once again, it bears repeating. The First Amendment applies to governmental restrictions of speech, not private conduct. The plaintiffs in Missouri v. Biden instead argue that the federal government coerced those platforms into censoring disfavored speech through the application of the platform's own content moderation policies. For reasons I detail in my written testimony, that contention lacks a reasonable basis in law and fact. In short, governmental officials offered their suggestions to platforms about misinformation, and no threat of adverse governmental action ever attached to whether those platforms took those suggestions or not. Social media platforms' content moderation decisions have always rested and remain with the platforms themselves. By attacking those platforms' attempts to combat misinformation, the plaintiffs in cases like Missouri v. Biden do disservice to the principles of free speech that they claim to support, and they invite the grave consequences of misinformation that they seek to spread themselves unchecked. It is perhaps not a coincidence that the proponents of measures that would handicap social media platforms' efforts to combat misinformation are often prolific purveyors of misinformation themselves. Senator Schmidt and Attorney General Landry, who just testified, filed a brief in the Supreme Court supporting a suit by the state of Texas seeking to block the counting of electoral votes from 4 states that President Biden won. Over 100 members of Congress, including members of this committee today, also filed briefs supporting that suit. Texas's complaint included the fantastical claim that the statistical likelihood that President Biden fairly won the 2020 election was less than 1 in quadrillion. That is false. Members of this committee have claimed that Dominion voting machines fraudulently flipped votes from Trump to Biden. That is false. Members of this committee have claimed that thousands of ballots were cast on behalf of dead and unqualified voters. That is false. Members of this committee have claimed that election workers around the country counted fake or fraudulent votes. That is false. And on October 19th, 2020, Chairman Jordan tweeted that Democrats are trying to steal the election after the election. That is false. Lies like these corrode Americans' faith in the integrity of our elections and our democracy. Those elections are, without question, fundamentally sound. These falsehoods formed the foundation of an unprecedented effort to reverse the results of a presidential election. And they are just a drop in the bucket, a drop in the ocean of the flood of lies that flooded social media in the weeks and months after the 2020 presidential election. This is not idle political theater. Across the country, election workers have been targeted by extremists with threats of horrific violence as retaliation for their alleged complicity in a stolen election. And just over 2 years ago, a violent mob stormed the Capitol building in an attempt to disrupt Congress's count of electoral votes. Some in that mob erected gallows on the steps of the Capitol not far from where we sit today. After the vice president honorably confirmed that he would abide by his constitutional duty, some in that mob chanted, "Hang Mike Pence." They did so because someone told them the lie, that the election was stolen. And they did so because someone told them the lie, that Vice President Pence had the power to reverse the results. Whether or not our Constitution and our fidelity to the principles of the First Amendment permits us to punish or prosecute those who told those lies, surely we can recognize the damage done. And surely we can recognize that the social media platforms, which now serve as the main channels of misinformation, need all the help they can get in combating it. It is both constitutional and consonant with the principles of the First Amendment for government experts to help social media networks in identifying misinformation and to encourage those networks to stop spreading it and amplifying it. I welcome the committee's questions.
Thank the gentleman for his testimony. The chair now recognizes the gentlelady from New York, Ms. Stefanik.
Mr. Siegelman, isn't it true that Democrats objected to President George W. Bush's victory in 2000 on the House floor?
Yes, it is.
Isn't it true that Democrats objected to President George W. Bush's victory in 2004?
Yes.
I yield the remainder of my time to Mr. Johnson.
I thank the gentlelady. The irony is so thick in the room today that you could cut it with a knife. First of all, the Democrat sole witness is this gentleman that comes to us from the Constitutional Law Center at Stanford Law School, where less than 2 weeks ago, the dean had to order mandatory training in the First Amendment to faculty and students after her apology for the debacle of them shouting down a Fifth Circuit appellate court judge. Were you present for that event?
No, I was not.
Okay. Well, and you just told us that we basically, the media networks need to censor viewpoints they disagree with. It's unbelievable. The other irony is that our Louisiana Attorney General, Jeff Landry, just explained to us in detail and put on a brilliant presentation with all the evidence pointing out that there is literally a censorship enterprise now in the Biden administration. And not 5 minutes later, our colleagues over here objected and wanted to strike his testimony as being too objectionable. I mean, we're illustrating the point right here as all of you talk. Many actors in the Biden administration, many of them, have and continue to harass and pressure social media companies to censor COVID-19. We now know that there was a coordinated campaign of both public and private pressure against the social media platforms. And who did it come from? As you've pointed out, President Biden himself, senior White House staff, Surgeon General Vivek Murthy, Dr. Anthony Fauci, the CDC. They targeted opposing COVID viewpoints. They targeted the viewpoints, folks. If you're watching at home, they volume censored you. They turned you down and they kicked people off the platforms because they said things that went against the administration's narrative. One piece of COVID information that President Biden's administration labeled as misinformation was the belief that the virus originated from a lab in China. We now know that is no longer just a theory, it's likely true, as some of the agencies of the government have had to admit now. Dr. Fauci himself was instrumental in contradicting the lab leak discourse from the very beginning of the pandemic. And listen, everybody needs to pay attention to this. He commissioned a research paper to discredit the theory. Can you please share with us what his interest was in covering up the lab leak theory, Mr. Sauer? What do you think about that?
Thank you, Congressman. The evidence in our case indicates that going back to 2011, Dr. Fauci had been a public advocate in favor of gain-of-function research, that starting at least in 2014, NIAID, under his direction, had publicly funded gain-of-function research on bat coronaviruses in the Wuhan Institute of Virology, and that in early 2020, when the virus was new, he became aware from briefings from his staff and emails from Jeremy Farrar of the Wellcome Institute in the United Kingdom that there was a grave risk that the virus had in fact leaked from that institution where NIAID-funded research on gain-of-function on viruses had been conducted, and you see an elaborate plot, a deceptive plot, to try and discredit that theory at that time.
And NIAID was his agency. When he was asked at a White House briefing about this report that he commissioned, he claimed he was unfamiliar with the authors of the study, even though he was instrumental in every single step of its creation. I have a video, if we can play that real quickly. We'll look at it in his own words. Go ahead. All right, well, they're trying to fix that. What Dr. Fauci says there in his own words is that he has no idea anything about the authors of the study, even though he's the one that orchestrated the whole thing. When he was asked in a deposition about his role in suppressing the lab leak origin theory, among other things, he said, and we have another video, it's not going to work, I'm sure, he said 300-something times that he doesn't recall, he doesn't remember. He isn't the only bad actor. Mr. Sauer, can you please elaborate on the ripple effects of President Biden publicly saying social media companies are killing people by failing to remove COVID information that his party disagrees with?
Evidence indicates that that was a critical watershed in the Biden administration's pressure campaign to attack Facebook in particular, but also social media platforms in 2021. And what you see is these amazing emails right after that July 16, 2021 comment from President Biden that they're killing people, from very senior Facebook, C-suite Facebook executives desperately scrambling to get back in the White House's good graces and assuring them, we will do what you want. We will carry out, quote, what the White House expects of us on misinformation going forward.
It has an incredible effect at chilling the speech of Americans. I yield back.
Gentleman's time has expired. Chair now recognizes the gentleman from Massachusetts, Mr. Lynch.
Thank you, Mr. Chairman.
You bet.
First of all, I want to correct the statement my colleague made that my objections were to the substance or content of the two witnesses that are now departed. My objection, as I stated before, was that if we are not going to observe the right to cross-examine witnesses that are providing substantive testimony before this committee, then we should strike that. And that is the practice in federal courts when much is at stake. And it is a device that ensures that when people take a stand and offer evidence, that we can test the veracity of their statements. But that is not the case in this hearing. The chair and the majority have chosen to allow witnesses to offer substantive testimony here and then have allowed them to scurry away and not face cross-examination or the testing of the statements they have made. You know, it's ironic that we began this hearing with a Pledge of Allegiance. We all stood and put our hands on our hearts and looked at the flag. Then we turned around and we eviscerated the very process here that would protect rights, protect the integrity of this hearing, to elicit the truth and to test the statements and testimony that are brought before us. This is such a departure. This is such a departure from regular order and the usual process of congressional hearings that I'm compelled to strike that, to ask to strike that testimony, because it's not worth anything if it can't be tested. Congress or the American people should not be able to rely on that information if it is not tested, not truthful. And so, Mr. Chairman, I resume my motion to adjourn. And I ask for a recorded vote.
Gentleman moves to adjourn. The committee will suspend while we prepare to have the clerk call the roll.
Mr. Chair, may the time be suspended, please, for that?
It is suspended.
It's still clock going
Oh,
down.
the clock for Mr. Yeah, we will hold the time for Mr.
Thank
Lynch.
you.
We'll get the clerk out here and we'll have the vote.
Ms. Jordan, point of inquiry.
Gentleman from California is recognized.
Mr. Chairman, I've testified before committee even during the 2 years I was out of Congress, and you and I have been here for more than a decade together. Have we ever cross-examined a current U.S. Senator who testified before any committee that you or I were on?
Nope, we have not.
Mr. Chairman, this is
Clerk,
debating the
clerk, I
point of
understand.
order.
No, it was
He's asking
as a point of inquiry. I just asked the question of the
Clerk will
chairman.
call the roll on the gentleman's motion from Massachusetts.
Mr. Jordan.
No.
Mr. Jordan votes no. Mr. Issa? Mr. Issa votes no. Mr. Massey? Mr. Massey votes no. Mr. Stewart? Ms. Stefanik? Ms. Stefanik votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Stubbe? Mr. Stubbe votes no. Mr. Bishop? Mr. Bishop votes no. Ms. Kamak? Ms. Kamak votes no. Ms. Hageman? Ms. Hageman votes no. Ms. Pascott? Mr. Lynch?
Yes.
Mr. Lynch votes yes. Ms. Sanchez?
Aye.
Ms. Sanchez votes aye. Ms. Wasserman Schultz?
Aye.
Ms. Wasserman Schultz votes aye. Mr. Connolly?
Aye.
Mr. Connolly votes aye. Mr. Garamendi? Mr. Allred? Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Goldman?
Aye.
Mr. Goldman votes aye.
Mr. Chair, how am I recorded?
Ms. Pascott, you are not recorded.
I vote aye.
Ms. Pascott votes aye. Mr. Stewart, you're not recorded. Mr. Stewart votes no.
All members voted. Clerk will report.
Mr. Chair, there are 7 ayes and 12 noes.
Motion fails. The gentleman is recognized for the remainder of his 5
Point
minutes
of
of question.
inquiry. Mr. Chairman, point of
The
inquiry.
gentlelady is recognized from Texas.
Mr. Chairman, I think we need to unconfuse the record. I mean, sometimes I hear you talk about Mr. Landry as appearing as a former member of Congress, and sometimes I hear you saying was Louisiana Attorney General. So
Those are both true statements.
those are two statements, but in what capacity was he testifying today? As a
It's
former
testifying as a,
member or as an elected state official?
he was testifying as a witness in front of the Subcommittee on the Weaponization of Government. The gentleman from Massachusetts is recognized for his 2
capacity,
minutes
sir?
and 17 seconds remaining in his 5 minutes of
In
questioning.
what capacity, sir?
Gentleman from Massachusetts is recognized.
Mr. Chairman, I should get an answer in what capacity he was here.
He was in the capacity of a witness in front of our committee. That was his capacity.
Attorney General.
Yeah, the gentleman from Massachusetts is
So is
recognized.
the president now set that any state official that
Precedent's
comes
now
is
set
going to
that
be
the
excused?
gentleman from Massachusetts is recognized for the remainder of his 5 minutes of questioning.
Mr. Chairman, I would.
Regular
like
order.
an answer.
Mr. Seligman, in the Missouri versus Biden complaint, today's witnesses, who are now departed, claimed that a February 2022 Department of Homeland Security threat bulletin somehow harmed them by warning that online disinformation could lead to real physical threats. I ask unanimous consent to introduce this February 7, 2022 National Terrorism Advisory System Bulletin. for
Without
the record.
objection.
Mr. Seligman, this warning obviously was not far-fetched, as evidenced by the events of January 6th. Members of the extremist groups like Proud Boys, the Oath Keepers, and 3 Percenters did not hesitate in calling for perpetrating violence on the basis of false or misleading election fraud narratives, and we need only to remember the chants of "Hang Mike Pence" outside this U.S. Capitol. I would also underscore that more than 60 lawsuits brought by President Trump and his supporters, especially Rudy Giuliani, following the 2020 presidential election failed because they lacked evidence to support them. Professor Seligman, do you agree that false or misleading narratives about the substantive election fraud could lead to calls for violence around elections?
Yes, I do.
Professor Seligman, the witness that we're sitting next to you seemed to think that it is censorship for DHS to warn that online disinformation could lead to election violence. Could you walk us through how disinformation can lead to that election violence?
Yes, Mr. Lynch. So if 100 million people see a false claim about voter fraud or election interference on a social media website, some number of those 100 million people may become outraged to a degree that they are willing to commit acts of violence. And that's exactly what we saw in the aftermath of the 2020 election, that these false narratives, these false statements of fact about the integrity of the election in 2020 were propagated, millions, hundreds of millions of people saw them, and some small number of those people took matters into their own hands and committed acts of violence that the members of this committee have seen.
Mr. Chairman, my time has expired. I yield back.
Gentleman yields back. I would point out that last Congress, the Democrats ran a committee in that Congress for a year and a half, which gave no ability to the Republicans to cross-examine one single witness. So we do believe the ability to cross-examine is important. We also believe in following the custom.
That's
Mr.
false.
Sauer.
Couldn't question witnesses at a
Mr.
hearing?
Sauer.
You are not allowed to question witnesses at a hearing? Is that what you're saying?
Mr. Sauer, you deposed Dr. Fauci.
Point of order. Mr. Chairman, could you clarify that statement because I find it incredibly hard to believe.
Point of
What
order, that's
basis
not a
in-
point of order.
What basis in fact do you
Gentlelady is
have
not
for
saying a point of
making
order.
that assertion?
The chair now
Are
records
we
himself
just
for
here
his
to
5 minutes
allege
of-
wild
5 minutes of
allegations
questioning.
and have no factual
Mr. Sauer,
thing to pick it up?
the gentlewoman has not been recognized. Mr. Sauer, you deposed Dr. Fauci last fall? In that deposition, you asked him the question, you said, is it important for people to have access to both sides of the debate so they can assess what's good information and what's bad information? Remember that question you asked Dr. Fauci? And here was his response. He said, Dr. Fauci said, well, you know, it depends. If information is clearly inadequate and statistically not sound, there can be a danger in people who don't have the ability or the experience to understand. Mr. Sauer, do you forfeit your First Amendment rights if you can't tell good information from bad information? That's not how our First Amendment works, is it? You need to turn on your mic if you can, Mr. Sauer. Is the First Amendment only those for those people who have the ability or experience to understand?
No, it is for all Americans.
All Americans, all 330 million of us, is that right?
That's correct.
Not just for the special people, not just for the super smart people like Dr. Fauci, who worked 40 years in our government, highest paid guy. Not just for them, it's for all of us, right?
Absolutely right.
Even if maybe you don't know the difference sometimes between what's good or bad information, you still have your First Amendment liberties under our Constitution.
Both to hear and to speak, absolutely.
Exactly right. By the way, when you deposed Dr. Fauci, how many times did he happen to say he didn't know or couldn't remember?
He said, I do not recall or variations thereof 174 times, and adding in variations of I don't remember at least 212 times.
Wow. Smartest man on the planet couldn't remember 212 times?
He couldn't remember things, including things that he had told the national media, quote, I remember it very well. Then he would say 16 times, I don't recall details of that meeting.
Now you you were near the top of your class at Harvard Law School, Rhodes Scholar, is that right, Mr. Sauer?
I've submitted a biographical statement.
Yeah. Well, I looked at your biography. It's pretty impressive. Is that pretty high? You've done a lot of depositions. You've done a lot of legal work. You've deposed a lot of people. Is 212 times pretty high?
I've taken dozens of depositions. I've never seen anything like it, including in this case where other federal government witnesses frequently profess inability to recall.
So the guy who told us all these things, who's, the smartest man on the planet, he set a record. Highest you've ever seen and couldn't recall, didn't remember?
I've never seen anything like it.
Okay, page 4 of your testimony, you talk about the censorship enterprise. You give a bunch of facts and numbers here. You said Twitter disclosed that 84 government officials communicated with them, or as Mr. Seligman said, gave them suggestions. 84 federal officials gave Twitter suggestions on tweets and things to take down. 45 officials in the federal government told the same thing to Facebook. Is that right?
They discussed disinformation and censorship with those officials.
Yeah, a handful of federal agencies handed over 20,000 pages of documents in the communications they had with these big tech companies. Again, just suggestions, though, according to Mr. Seligman. 20 White House officials were involved in these suggestions to these social media platforms.
That's conservative. It's probably higher.
Yeah. FBI agent Elvis Chan testified the FBI alone sends encrypted lists to social media accounts, sometimes containing hundreds of accounts and URLs in each list to platforms for censorship 1 to 5 times per month. 500 times a month, 500 different email or websites, everything else they're sending to these social media platforms. The FBI, and Mr. Seligman says, don't worry, that's not a problem with the First Amendment. That's a suggestion.
Yes, over the course of years, that's been occurring.
The Election Integrity Partnership, a censorship consortium of academics, think tanks, federal and state government officials, social media platforms boast that it surveilled 859 million tweets, 21 1,897,364 tweets on tickets as misinformation. Is that right?
That's correct.
You learned this in your discovery in your lawsuit so far.
Correct, Your Honor.
And the Virality Project, a mass surveillance and censorship operation conducted by the EIP, has done over 6.7 million engagements on social media, 200 million. Now, let me just ask you this. Were most of those targets towards conservatives?
Virtually everything we've seen in evidence so far, or at least the vast majority of what we've seen in so far, is conservative, right-leaning speech.
But you would be just as outraged. I read your testimony. You'd be just as outraged if it was the other way around, right?
Absolutely, because
Same here. Same here. Because the First Amendment, again, is not just for some people, not just for one political persuasion, not just for the so-called smart people like Dr. Fauci. It's for 330-some million Americans. That's how our Constitution works. Is that right, Mr. Sauer?
every single American.
I thank the gentleman for his answers.
Mr. Chairman, I have a unanimous consent request.
Gentleman from Louisiana is recognized.
Seek unanimous consent to enter into the record a letter dated January 12, 2021 by Louisiana Attorney General Jeff Landry, where he decries all political violence and calls for an end to that and asks for respect for all political viewpoints.
Without objection.
Another
so
thing
entered.
we can examine because he's not here. Very good.
No, you can
Thank
examine
you.
it. It's a document. He's going to
No,
enter into the
examine
record.
him for what he wrote and the intent behind what he said.
Well, I would
But,
just
okay.
I would just point out that that's unanimous consents are for documents, and we got the document right here that he handed to you.
Mr. Chairman, I would ask unanimous
Chair
consent.
now recognizes Ms.
Mr.
Wasserman
Chairman,
Schultz for her 5
I have a
minutes.
unanimous consent request, Mr. Chairman.
Pardon?
I have a unanimous.
Oh, okay. Gentlelady is recognized for unanimous consent request.
Yes, I have a unanimous consent request to enter into the record the Merriam-Webster's definition of salacious, which says arousing or appealing to sexual desire or imagination, lecherous or lustful, so that my colleague from Louisiana will not misuse that when describing the testimony of our colleagues here in Congress.
Well, as Senator Schmidt said earlier, there was
I
a
would
lust for
ask that it be
censorship, but
entered
I'll
into
withdraw
the
the word.
record. I would ask that it be entered into the record, Mr. Chairman. It's a document.
Yeah.
I said
already
outrageous,
without
but I'll
objection.
withdraw it.
I don't think the gentleman's objecting, so it's entered into the record. The gentlelady from
Thank
Florida,
you.
Ms. Wasserman Schultz, is recognized for 5 minutes.
Thank you, Mr. Chairman. This is our third hearing, and unlike the previous two, I find it ironic that the Republican majority brought us a witness who actually weaponized the government himself. Mr. Sauer, Sunshine record requests show that you worked with the Republican Attorneys General Association and its dark money political arm, the Rule of Law Defense Fund. They also indicate that you took part in these groups' quote-unquote war games on how to respond if Trump lost the 2020 election. Very quickly with a yes or no answer, please, Mr. Sauer. Is that correct? Yes or no? The answer is yes? No? Yes or no? You worked with the Republican Attorneys General Association and its dark money political arm, the Rule of Law Defense Fund. Sunshine record requests show that you did. And to confirm that, I have an official state email that points to your involvement in these political efforts, and I ask unanimous consent to enter it into the record.
Without objection. Ms. Sauer, make sure your microphone's turned on.
So the answer to that question is yes, Mr. Sauer?
That is not what I said. I said that you've significantly mischaracterized those
Okay, Mr.
involvements.
Sauer, I remind you that you're under oath, and behind me, and I just entered it into the record, I have a copy of an official state email where you responded to a message on these war games, very specifically. Okay, Mr. Sauer, the Rule of Law Defense Fund put out a robocall recruiting people to march on the Capitol on January 6th to quote-unquote stop the steal. Can we play that for, please? Okay. Okay, it's also, you can see that recorded message behind me. I must say, Mr. Sauer, when you planned, okay, let's move on past the audio. When you planned with these groups, what you planned with these groups was certainly no game, but it definitely resembled a war. You can see the pictures. This is an excerpt of the audio call. Now, these same dark money groups held at least 30 meetings for state attorney general senior staffers, including you, during the 2020 presidential campaign, even though I'm sure you knew that Missouri law bars state employees from using state resources for political activity. Missouri lawmakers were wise enough to make it illegal to weaponize state government facilities for political purposes, or in this case, to subvert America's democracy. Approximately how many of these political meetings did you attend while in your office and using state resources? And before answering, let me remind you, your Fifth Amendment protections against self-incrimination do apply here if you need to use them.
None of the meetings I attended were political. I attended one meeting by Zoom that discussed legal issues only. So
Okay.
everything you've
Those
said
were-
about the characterization,
okay.
if I may,
Reclaiming-
everything you've
no,
said about that
reclaiming my time,
characterization is
reclaiming my
misleading.
time. Attorney General staff members also attended one of these war games meetings on January 5th, 2021, on the very eve of the insurrection. Mr. Sauer, did you attend or participate in this meeting on January 5th, 2021? And can you share with us what war game strategies you discussed?
I did not attend in that meeting. I was unaware of it.
Okay.
I'm not sure of the meeting you're referring to.
Okay, more bluntly, Mr. Sauer, did you violate Missouri Statute Section 36.157 by using state resources on official time to collude with political groups to prevent America's peaceful transfer of power?
Absolutely not.
Mr. Chairman, thank you for finally bringing a witness before us that has personally weaponized the government. Mr. Sauer did participate in war game meetings with the dark money group, the Republican Attorneys General Association. Given what we know and just heard, clearly my Republican colleagues would support further investigation into this matter. We have evidence. This is a state email suffix. It was during the time of day, during the work hours. So I move that the chair issue subpoenas to Mr. Sauer requesting any and all correspondence relating to their political involvement in the January 6th insurrection and dark money groups while using state resources. That's my motion, Mr. Chairman. And then we need to hold the time, please.
Yeah, hold the timer just a second.
We have to roll the time back by about 6 or 7 seconds.
Okay, the gentlelady has moved to issue a subpoena. We will have a roll call vote on that, and the gentlelady will suspend while we get the clerk prepared for that vote.
I make a motion to table.
Gentleman's made a motion to table the motion to issue a subpoena. As the clerks are getting ready, let us sort this out.
It's fine. Just want to point out that they're tabling the motion so that we can't get more information that shows that Mr. Sauer weaponized government, used and violated Missouri state law by
Okay, hold on.
by-
We have a motion
by
pending.
colluding with a political
The gentlelady will
organization
suspend.
to
The gentlelady will
overturn a presidential election.
The motion to table is not debatable. The clerk will call the roll.
Mr. Jordan? Mr. Issa? Mr. Issa votes yes. Mr. Massey? Mr. Massey votes yes. Mr. Stewart? Mr. Stewart votes yes. Ms. Stefanik? Mr. Gates? Mr. Gates votes yes. Mr. Johnson of Louisiana?
Yes.
Mr. Johnson of Louisiana votes yes. Mr. Armstrong? Mr. Armstrong votes yes. Mr. Stube? Mr. Stube votes yes. Mr. Bishop? Mr. Bishop votes yes. Ms. Kamak? Ms. Kamak votes yes. Ms. Hageman? Ms. Hageman votes yes. Ms. Plaskett?
No.
Ms. Plaskett votes no. Mr. Lynch? Ms. Sanchez?
No?
Ms. Sanchez votes no. Ms. Wasserman Schultz?
No.
Ms. Wasserman Schultz votes no. Mr. Connolly?
Nay.
Mr. Connolly votes nay. Mr. Garamendi? No. Mr. Garamendi votes no. Mr. Allred? Ms. Garcia?
Nay.
Ms. Garcia votes nay. Mr. Goldman?
No.
Mr. Goldman votes no.
Clerk will report.
Mr. Chair, there are 10 ayes and 7 noes.
The motion carries, and it is tabled.
Reclaiming my time, Mr. Chairman.
Gentlewoman's recognized. Complete her time.
I think we've made it very clear that the Republican majority has no interest in investigating true violations of the weaponization of government. They just tabled a motion to get more information to demonstrate that, and I'd ask with the remainder of my time, I think the video is ready so that we can play it. Thank you. Mr. Chairman, can we play the video, please?
Is that video ready?
Okay. I guess it's still not working. It would be nice if we could get the audio visuals working here in the committee. This hearing is fixated on a red herring. Studies show conservative voices are more prevalent on social media. We need to make sure that we are getting to the bottom of the weaponization of the federal government. But this committee is only interested in selectively doing that, as evidenced by the fact that the Republican majority on this committee squashed getting us more evidence than what I have behind me that I've entered into the record to proves that this witness, Mr. Sauer, weaponized government and participated violating Missouri state law
Gentlelady's time's expired.
in politicizing and trying to overturn an election.
Gentlelady's time's expired. Gentleman from California is recognized.
Thank you, Mr. Chairman. I'm going to try and return to the subject as much as I can of this hearing. Mr. Fowler, are you familiar with the case in California disputing the governor's order for universal ballots?
No, Congressman.
Okay, well, oddly enough, I was the plaintiff. So, and oddly enough, the governor then went to the legislature and got the authority to have universal ballots, and then the case was dismissed. Isn't part of free speech or the First Amendment the right of redress?
That is correct, to petition the government, exactly.
And petitioning the government has been widely considered to be including to make cases before the federal court when you believe that the Constitution is being violated or your free speech is being violated or due process is being violated. Those are all consistent with what we would broadly say is the First Amendment.
Correct.
And for the record, the First Amendment, incredibly short, and if we read it in its purest sense, you would say that Congress shall make no laws respecting. And that because it only says Congress, that it doesn't apply to anyone else. Have our courts, including our Supreme Court under 200 plus years, have they ever considered it that narrow?
No, Congressman.
So isn't it true that they basically consider censorship of free speech very broadly to include intimidation by federal, state, or local government authorities? Isn't that right?
Yes, intimidation and retaliation, among many other things.
So what was earlier called suggestion by the federal government, the vast power of the federal government, which could even include the IRS, one might think in this case, that kind of suggestion has historically been viewed as intimidation consistent with this relatively short statement about our right of free speech.
That's exactly right. There's overwhelming evidence in our case that contradicts the notion that these were mere suggestions from federal officials. It's completely factually baseless to state that.
So you earlier testified that the vast majority of this was one-sided and came from government officials who wanted to take down things which disagreed with the government in place at that time, which happened to be the government of Joe Biden, correct?
Correct.
So what we really have here is something similar to historically Nixon v. the IRS, if you remember that era, and that's not the actual case name, but what you have is the power of the executive branch being used to reduce the opposition or the redress or the free speech or the communication of people who might disagree with what was being put out by the executive branch, which happened to be a Democrat president.
That's exactly right. We see not just interference with free speech, but interference with the attempts to organize for political advocacy.
Now, is this an opinion, or are these indisputable facts based on the literally millions of events?
Yeah, the evidence is overwhelming, and we've submitted extensive evidence to the subcommittee.
So what we're dealing with here is tangible evidence that the other side of the aisle seems to want to talk around about the changing of what would have been public opinion if public opinion were freely allowed to occur without intervention by the federal government and, candidly, agents on behalf of them, including private entities that were paid to be part of this program.
That's correct, and you do see a concerted effort to change the subject.
So I would like to use the remainder of my time to give you an opportunity to speak to some of the personal attacks that were just made on you, if I could.
Very briefly, I would note that all the questions that came from the other side there were misleading in the way they were characterized. They mislead my involvement. There's no suggestion that anything I did was before the 2020 election was inappropriate or involved a misuse of state resources. I categorically deny that. It is false. That is misinformation. However, I recognize the member's right to say misinformation because you know what? That's protected by the First Amendment, contrary to what Mr. Seligman is suggesting in his testimony.
Well, I very much appreciate it, and hopefully we will return to the debate that allows both sides to speak without having personal attacks on their character, and I yield back.
Gentleman, time expired. The gentleman from Virginia.
Truth hurts. Truth hurts.
The gentleman from Virginia, Mr. Connolly, is recognized for 5 minutes.
Thank you. You know, been through a lot of hearings, seen a lot of member panels, and I must say, I find it disconcerting that we are not able to ask questions of two of our witnesses. If they're here to simply present their thoughts and their idle opinions, so be it. But if they are presenting themselves as quasi-experts on censorship, I think we have a right to question them. But even if Senator Schmidt and Attorney General Landry aren't here, I think it's important to note that every single witness of the majority took part in the effort to overturn the 2020 election. And all three of them have interconnecting relationships, very convenient for a panel. If we turn our attention to the screen, please, the email sent to state attorneys general.
Suspend the clock for me while we get that going.
I thank the chair. I don't think that's it. It's the email from Mr. Sauer. Mr. Chairman, I don't understand our technical problems, but Mr. Sauer sent out an email to state's attorney
Start
general.
the clock again for me if you're going to testify. Okay. Gentlemen, continue.
Okay. And asked for responses by 12/9, 1 o'clock. Mr. Seligman, this email is signed by John Sauer. Is that the gentleman to your left?
I believe so.
When Donald Trump lost the 2020 election, Mr. Sauer was working for then Missouri Attorney General Schmidt, who testified here this morning. And they worked together to find 16 other Republican state attorneys general, including Attorney General Landry, who's running for governor, to join them in an amicus in support of a lawsuit to overcome the election. Now, his team filed this case on December 8th, and the Supreme Court rejected it 3 days later. Why did the Supreme Court reject?
So the Supreme Court rejected, so it didn't issue an opinion explaining why it rejected that. So I can't speculate about what was going through the minds of the justices. But I can tell you about the legal flaws in the complaint that rendered that decision correct. So the state of Texas sued other states, including Pennsylvania, Michigan, Wisconsin, and Arizona, for allegations that there were flaws in the election in those states. And the state of Texas claimed that it was injured as a state because the alleged maladministration of the election in other states somehow undermined its own sovereign rights in the Electoral College. And that is a radical and unprecedented claim that no court has ever accepted.
Including the Supreme Court.
Including the Supreme Court.
And one must say, they kind of dismissed it with dispatch.
That's correct. It was
3 days later.
Yes, it was 3 or 4 days later. Now, the Supreme Court dismissed it unanimously. A point of clarification about that, there was a concurrence in the dismissal by Justice Thomas and I believe Justice Alito explaining that they would accept the bill of complaint because they think as a matter of Supreme Court procedure, the Supreme Court can't just refuse jurisdiction, but then they went out of their way to say they would grant no other relief, which is to say that they would reject the claim on the merits.
So the allegations in the lawsuit range from claims of illegal voting to accusations about Dominion voting machines, now the subject of a civil defamation case with Fox News. Even Fox News reporters called the claims contained in the lawsuit dangerously insane. Why might Fox News reporters call this kind of lawsuit dangerously insane?
Well, the factual allegations that I believe they were referring to are demonstrably incorrect and have no basis in reality whatsoever. So, and it was apparent at the time as well. This is not something that just became apparent in the months and years after those allegations came to light.
Well, it's certainly comforting to know that we have a panel that includes 3 people who are involved in a lawsuit that has been declared dangerously insane by none other than Fox News reporters. That's a comfort. I thank you, Mr. Seligman, for your testimony, and I yield back.
Gentleman yields back. The gentleman from Utah, Mr. Stewart, is recognized for 5 minutes.
Thank you, Chairman. Mr. Seligman, I'm curious, just as a sidebar, were you embarrassed by what happened at Stanford Law School a few weeks ago?
So I'd like to clarify that I am...
In regards to the suppression of free speech with the federal court, district court judge?
So I'd like to clarify that I am testifying here on my own behalf and not on behalf of...
I understand that. I'm just curious. I mean, I would imagine you would be embarrassed by that, but are you familiar with GDR, East German Stasi secret police?
I'm sorry, can you speak
up a little bit? Are you familiar with GDR, the East German Stasi secret police?
Generally, yes.
Generally, yeah. We know they use techniques of threats and intimidation, censorship in order to maintain and control and ensure continuation of government power. They're one of the most repressive and powerful forces that we've seen in our modern world. Now, I'd like to quote some of their objectives and some of their tactics that they would use. The aim of the Stasi was to switch off a group or private citizens by hindering any positive media or public exposure to their thoughts, views, and policy positions, including pressuring newspapers and other media. Would you be comfortable with the government using those kind of tactics in order to suppress thoughts, views, and policies?
If your question is whether I'm comfortable with the American government using the tactics of the East German Stasi, the answer is no.
Thank you. Mr. Sauer, do you see any difference between Stasi secret police tactics and government suppression of individual expression on social media?
Make sure your microphone's on. Sorry.
There's a very strong analogy to be drawn there, and it's based on overwhelming evidence.
Well, I see no difference at all.
It's a very close comparison.
I think it's an incredibly close comparison. I mean, I would reemphasize, including pressuring pressuring newspapers and other media in order to hinder any positive media or public exposure to their thoughts, views, or policy positions. There's no difference at all.
That's correct.
Let me give you another example. We're talking about the East German Stasi and the tactics they used. Another one, conspicuous visits to homes or workplaces so that citizens would be aware of and intimidated by their presence and power. We had a journalist here who was not a conservative journalist, by the way. He was here for a matter of a few hours talking about the weaponization of the federal government, and during that time, the IRS showed up at his house, something that the Secretary of Treasury admitted only happens, so far as she knows, when someone is under investigation for fraud and they need a personal interview. That's the only time she knew of some IRS agent appearing at someone's house. That happened while he was here testifying for our committee. Mr. Seligman, does that appear as an unlikely coincidence to you?
I'm not familiar with the factual details of Mr. Tybey's taxes.
As I've described it, does it seem unlikely to you?
I am not familiar with this incident, so I can't comment.
Well, I've explained the incident to you. He was testifying before Congress, and the IRS went to his home.
I have no idea whether it's a coincidence.
Okay, Mr. Sauer, how does it appear to you?
The timing is incredibly suspicious.
It's incredibly suspicious. And I'll quote again from Stasi Secret Police Tactics: conspicuous visits to homes and workplaces so that citizens would be aware and intimidated by their presence and power. I think my description to you is sufficient that you could make a judgment of that.
Again, I'm not familiar with the details of Mr. Tybey's taxes.
All right. So I'm surprised that you wouldn't want to condemn that. I'm surprised you wouldn't want to say, you know what, as you've described it to me, that makes me uncomfortable, that the IRS would show up at someone's home while they're testifying before Congress.
As a matter of principle, government retaliation for the exercise of free speech is problematic. It's wrong. I have no idea whether that has taken place in this
so
case.
conceding that you don't know if that's happened, you would be uncomfortable if that were the case.
I am uncomfortable with violations of the First Amendment.
Thank you.
Yes.
That's what we're talking about here. And I know you've seen on display the emotion of our colleagues on the other side of the aisle. I'm shocked that they don't want to condemn it. I'm stunned that they don't ask you the same questions that we ask. How in the world could anyone sit and listen to this and go, you know what, that's okay with me? Use the federal government as contractors to go suppress free speech. They don't do it themselves. They instead pressure and intimidate and threaten individuals and organizations to do it for them. There is no difference between that and what the Stasi secret police did. No difference at all. And if someone wants to stand and defend that, I will yield the last 7 seconds of my time to you. Chairman, I yield back. Thank you.
Gentleman's time's expired. Votes have been called. The committee will stand in recess until the conclusion of this 9-vote series.
I'd like to call to order